Cove Productions presents the Solo in South Philly podcast with your host and local legal whiz, with knowledge, Mark Kachi.
What's good, everyone? Welcome to the Solo in South Philly podcast. Our season 1 is called Law School Reunion. It's a remix with the homies from the Midwest side. Each episode, I will be reuniting with a different law school colleague. We will discuss what led them to law school, their law school experience, and what they do now. Our guest today is Professor Ron Bretz. Ron Bretz is an emeritus professor of law, having retired from the Thomas M. Cooley Law School in 2013. He taught criminal law and criminal procedure and was chair of the criminal law department. He was also a 5-time winner of the Stanley Beatty Teaching Award. Before Cooley, Ron spent 20 years as an assistant defender at the State Appellate Defender Office. He earned a BA with honors at Michigan State University in 1973 and a JD at Wayne State University Law School in 1976. He has regularly lectured and written articles reviewing criminal law decisions of the Michigan Appellate Courts. He has also written and lectured on the use of scientific evidence in criminal cases. Professor Bretz was a very well-distinguished professor at Cooley, but he was also very accessible and down to earth. For this reason, he was voted often to speak at graduation on behalf of the faculty. He was a favorite professor for a number of my guests. I wanted to have him on to share his practice experience as well as his experience as a professor in law school. Let's welcome Professor Bretz to the program. How you doing, Professor?
I'm doing well, thanks. Glad to be here.
Great to have you on. So everyone knew you as Professor Bretz, but let's talk a little bit about your life before becoming a professor.
Sure. I grew up in the city. I'm not going to give you everything, but I'm just the thin background. I grew up in the city of Detroit, and even though I went to Michigan State University for college, a terrific experience, by the way, I went back to Detroit to go to law school at Wayne State. And when I graduated, I was not a law review student. I was not the kind of guy that was getting invited to interview with the big firms. And at the time I thought, oh, this sucks, but I'm grateful. I found out about when I was still a student, I found out about a job opening for students at the Michigan State Appellate Defender Office. At the time I heard about it, I thought it was the appellate court. And like the Michigan Court of Appeals, I said, they're never going to hire me. Little did I know it was a public defender office. And I called them, we're interviewing students, but we need your resume by tomorrow. So I quickly got out our manual typewriter. This would have been 1974. Got out our manual typewriter and typed up a resume, the first one ever for me. I didn't even have online formats to look at, but it did the job. And my first year moot court brief that I had written for research and writing, I took those down there. They called me in for an interview, and I got all dressed up in my only cheap suit. And I went down for the interview, and the guys interviewing me were wearing jeans and T-shirts. And it was very casual. There were kids playing on the floor and anti-war posters on the wall. And I walked in there and said, oh my God, this is me. This is heaven. Or as one other attorney said, first time he came in, he went, wow, Woodstock, the law office. And so I worked there for 20 years doing appeals. It was a public defender office doing criminal appeals. That's all we did. So I appeared in court maybe once or twice a month for a half hour, just to do one oral argument a month, maybe 2, maybe 3 in a big month. So, and then occasionally I would do remand hearings, meaning the appellate court would send us back to the Court of Appeals, back to the trial court, just to augment the record, ineffective assistance of counsel hearings, things like that. So I did some trial court work, but never in front of a jury. And I loved it. I became a law geek, which I never thought I would. One of the things you have to do to be a good appellate lawyer unlike good trial lawyers, good appellate lawyers have to know the law inside out. And trial lawyers, you're flying by the seat of your pants most of the time. You try to get updates, you try to keep up with the law, but it's really difficult. For appellate lawyers, it was a luxury. I mean, we got to be able to read every case as it came in from the Michigan courts and keep a catalog of those cases to know when we could use them in our briefs. And I really enjoyed it. I represented murderers, rapists, shoplifters, literally in one case, a gravestone tipper. I went into the cemetery and small town. You don't do that in a small town. They'll send you to jail. So I loved it. I absolutely loved it. But I'd been there 20 years and I thought, am I going to be a public defender the rest of my life? And I had some friends who were at Cooley, teaching at Cooley. In fact, two of my colleagues at the appellate defender office were already, three were already at Cooley full-time. John Nussbaumer, Nora Passman Green, and Ann Miller. And two of them, Nussbaumer and Miller, became deans. I'm sure they were probably deans when you were there. So I had friends on the inside. And I had done scholarly work. I had published in law reviews when I was still working as a public defender. So when the time came to apply at Cooley, I thought, this is what I'll do. This is a great way to get out of, to change my career into something a little different. And as one professor joked to me, are you sure you want to trade sociopathic criminals for paranoid law students? Not my line. I'll attribute it to another professor. And I said, I'll give it a try. And if you were ever, for those students who were in one of my classes, the one thing they knew is that I loved being there. I loved what I was doing. And my classes were typically, for most of the students, enjoyable. There were those who I would anger because I held their feet to the fire, and then the criticisms that I would get, first and foremost, was, what is it with this guy? He's so easygoing in class, and then his exams are a bitch. And I thought, I'll agree with that. That's what I get paid for. Okay. Class should be interesting, enjoyable, and you'll learn something, because I know this stuff. Well, at least I used to. I forgot half of what I learned. But the exams, you got to prove to me you know your stuff, or you're going to fail the bar exam. If we let you matriculate, a word I didn't learn till I got to Cooley. If we let you get all the way through and graduate without holding your feet to the fire, you are going to fail the bar exam many times if you choose to do that. So anyway, there's the medium answer.
Gotcha. So let's go back a little bit before we get to your career at Cooley. Mm-hmm. One thing I wanted to ask you about that you mentioned, you said appellate work versus trial work.
Yeah.
So this is how I've always imagined it. When you're doing appellate work, would you say there's more emphasis on the brief and the oral argument is more of like for show, whereas in trial, it's kind of the opposite? Would you say it's like that?
Apparently you've done appeals or you've talked to appellate lawyer. And judges will tell you that. A judge will say, look, 90% of the time, the cases are decided based on the briefs. And the way it works in many appellate courts, and in both the Michigan Court of Appeals and Supreme Court, your briefs go to a pre-hearing panel of lawyers, right? And the lawyers, I think they're called the pre-hearing division in the Court of Appeals. They're called commissioners in the Supreme Court. But they review both briefs and they check the transcript, right? If one of the sides says this happened at trial, but there's no transcript cite for it, then they're going to have to find it. And if it's not there, then they're going to have to make sure the judges know this side made up facts. But so, and then they recommend a disposition, which the judges, let's face it, they're swamped with cases. So in many cases, they'll check it out, read the reports and go, yep, this sounds like the right disposition. And the pre-hearing division has provided the appellate court, the panel of judges, with a sample opinion. And the opinion that often gets issued is indeed that opinion. What good did oral arguments do? Nothing. And so many lawyers, including in criminal cases, waive oral argument. They simply say, because on the brief, you have to write oral argument requested when you file your brief. If you don't write that, then they don't put you on the schedule. So a lot of lawyers don't ask for them, including court-appointed lawyers back in my time. Excuse me here. I'm glad this isn't going to be on the air because I have allergies. At any rate, so the Supreme Court of Michigan, shortly before I left SADO, that was our acronym, State Appellate Defender Office. Shortly before I left there, they came out with minimum standards for assigned appellate counsel. One of them was you have to visit your client in prison. We at SADO always did that. You have to appear for oral argument. We at SADO always did that. Okay. So I would show up for oral arguments. Prosecutors often weren't there. So I'd get up there. The judges would say, look, we know what this case is about. If you got anything new, tell us. But I still enjoyed them. It was my one chance to be in court. And I got to know some of the judges. They'd see me, they knew who I was and they knew that I didn't lie to them. And that's real important, and you all learn that in law school. Once you got your reputation. Once you lie to a court, boy, that's going to be it. But anyway, yeah, you're right. Sometimes oral arguments make a difference. And so that's why I encourage doing them, particularly in good cases or close cases. They sometimes make a difference. Since we were court appointed, I'll readily admit many of my cases were dogs. I mean, they weren't going anywhere. I had to scrape the bottom of the barrel to come up with an appellate issue. And I knew they weren't going to go, but I'd still show up for oral arguments. And I would stand there and say, Your Honor, Your Honors, I rely on my brief unless the court has any questions. And so I was there for questions. If they had them, I'm ready to answer them.
Gotcha. Very good. So along those lines, I would say if people were to ask, if you were to poll people about Professor Bretz, there's a few things that I think everyone would say, but I would say one of the biggest ones is your claim to fame that you argued a case in front of the United States Supreme Court. So let's talk about that. Yeah,
that was a blast. That was a trip. It was 1984. So I've never been shy about giving my age. I believe in 1984, I would have been, I was born in 51. So that makes me 33 years old, right? Mm-hmm. Yeah. So fairly young. I mean, we become lawyers in our late 20s. So I'd been a lawyer for maybe 5 years. And I had a case involving a mass murderer. He killed 3 people in my case, all in the same place. But he'd been doing this for years. So he's also a serial killer. And that's real rare to find both of them in the same individual. He worked for the railroad in Michigan, but he lived in Indiana. And the railroad at the time, they were called Conrail. They later became Amtrak. And they signed a contract with the Michigan Railroad Workers Union that the Michigan union workers would unload the trains that come or go from Michigan. So the railroad workers in Michigan would ride the trains to Indiana to unload them. Well, my client lived in Elkhart, Indiana, and his job, he was non-union, he unloaded trains. Well, he lost his job. The union squeezed him out of a job. That's how he viewed it. So he took it upon himself to shoot Michigan union workers. They would find, I think, 2 or 3 dead Michigan union railroad workers in various places. Well, one of his victims lived, identified him, and he went off to prison, convicted of assault with intent to murder, no prior record, convicted of assault with intent to murder, got 10 to 20 years, did his 10 years. 2 days after he got out, they find 3 dead railroad workers in Jackson, Michigan. They get a phone call. The security at the railroad station, because they're in the station on New Year's Eve waiting to take a train for the ride home. They're in the employees' lounge, basically, which was, in a horrible irony, they called it the dead end room. That's what the railroad workers called it. So they find 3 dead bodies in there of railroad workers. So security calls the Jackson police and tells them, there's this guy, Rudy Bladell, he just got out of prison, but he's known to do this kind of stuff. If he's in town, he's probably your guy. Well, the cops find Rudy the next morning getting on a bus to go back to Elkhart. He didn't ride the trains. And they took him in, but they had no evidence, nothing, except his background. You can't charge somebody, so they had to let him go. And they knew he did it. I mean, they were on his butt the whole time, but it wasn't until the snow melted in the spring that somebody found the shotgun that was the murder weapon. And all the forensic testing showed that this was the murder weapon, and it had been purchased by Rudy Bladell in Elkhart, Indiana. Oh boy, that's enough to arrest him. Anyway, long story, let's cut to the chase. He comes back, they bring him back. He's given Miranda warnings in the car on the way back by the Michigan detectives. He invokes his right to remain silent. So they bring him back. He's arraigned in front of a judge where it's the reading of the charge and the appointment of counsel, setting of bond. There's no bond for murder in Michigan. But the judge says, do you have an attorney? He says, no, I can't afford one. I live in a shelter. He said, okay, we'll appoint an attorney for you, but I strongly advise you, until that attorney gets there, don't talk to anybody. A good judge, right? Giving him nice advice. So Rudy goes back to the jail. Now, this was Friday afternoon. Monday morning, the detectives come to see him, give him Miranda warnings. He waives his rights, and he fully confesses, okay? Gives a full confession to everything. And the attorney shows up Monday afternoon and basically says, you did what? And then has to go fight this case. Well, the attorney argued that when Rudy invoked his Miranda rights, the cops weren't allowed to revisit them. But if you remember the Mosley case, if you only invoke your right to remain silent, they can revisit you as long as they've given you a chance to think about it. And they did that. If you invoke your right to counsel under the Edwards case, they have to leave you alone unless you re-invite them or counsel is present, neither of which happened here. Well, he did not specifically invoke his right to counsel, except at arraignment he did, right? He told the judge, I want an attorney. So what I argued in the Michigan courts was, we agree this is a Sixth Amendment right to counsel case, not a Miranda right. This is not Edwards. But this is the real deal right to counsel. This is a Sixth Amendment right. The Miranda right was made up by the Supreme Court. And that's the right that's at issue. If this made up right, and I didn't call it that, but I said, if this made up right is going to get this kind of protection, what I called in my criminal procedure class, the stop sign of Edwards and not merely the yield sign of Mosley, then certainly the Sixth Amendment, the real deal, should get the same level of protection. The Michigan Court of Appeals said no. The Michigan Supreme Court said yes. I win. Yay, the confession is suppressed. So I'm feeling really good about my victory, right? And believe me, you know, I think you understand this, and almost all lawyers do, but the general public doesn't. But this guy was a mass murderer, serial killer. When you're a lawyer, that can't matter. What matters is, did you raise all the correct legal issues in this case and fight for this client? That's your job. So when basking in my glory, I get in the mail from the Jackson County prosecutor a copy of the writ for petition of certiorari to the United States Supreme Court. I go, oh, no, come on, man. I won. What are you doing this for? Oh, because I won. That's why he's doing it. So I wrote a response, which I thought was a good response, but I couldn't sign it because I was not a member of the U.S. Supreme Court bar, but my boss was. So my boss signed it with my name, on the brief or whatever. And we filed it and figured, they won't do anything with it because it's clearly a correct decision. Well, I come into work one day and out in the street is the USA Today coin box, and I said, I'll buy a USA Today. Now, remember, still no internet. I'll buy a USA Today because there was an article about a major Supreme Court decision that I wanted to read about. So I did, to complete the article, turn to page 4A. So I did. And on the side of the page in a box, in other action, the court yesterday did the following. And I'm reading through it. And one of the little blurbs, which is maybe an inch big, says, in a case from Michigan, granted certiorari to decide whether the Sixth Amendment right to counsel applies to post-request confessions or something like that. And I swear to you, my first reaction was, wow, how weird. This sounds exactly like my case. There's another. Wait a minute. This is my case. So I went running down the halls of my office. There's like 6 attorneys in the office where I was in Lansing. They granted certiorari in my case. They granted certiorari. And I'm running up and down the hall. And one of my colleagues said, slow down. How do you know it's your case? And I said, well, look. He said, well, it doesn't name the case. What should I do? He said, call the clerk's office. So I call the clerk's office. Yeah, that's the case. So now I know I've got one. But I'm the respondent, so I have to wait for the petitioner to file a brief, his actual brief. Now that the writ's been granted, he files a shotgun brief, right? The Sixth Amendment doesn't apply to interrogations. Well, if you've ever read Messiah, the primary Sixth Amendment case, yes, it does. He tries everything. So I filed my response, which I thought was a pretty good one. Lots of law review articles telling me I'm right, and very little case law. But there was a conflict in the circuits, which means that's ripe for certiorari. That's probably why they granted it. So we go to oral arguments in November of 84, and or was it 85? Yeah, maybe November of 85. And my parents came, my wife came, 5 or 6 of my colleagues from the appellate defender office came. This was a big deal. We didn't go down there very often. This
is Washington, D.C., the iconic steps, the place.
And it was long enough ago that Thurgood Marshall was on the court. William Brennan was on the court.
Wow.
Stevens wrote the opinion. Berger was the Chief Justice. And so, you get all these instructions on what you're supposed to do. Like, for example, you get a little card in front of you on counsel table that says, when it's your turn, the Chief Justice will call you by name. Do not introduce yourself, right? So the thing we teach all moot court students at Cooley, good afternoon, Your Honors. My name is Ron Bretz, and I represent the respondent. No, it's, may it please the court, Mr. Chief Justice, Associate Justices. I mean, that's really formal. But I go down there, and the prosecutor goes first, and he gets into for lack of a better term, a pissing contest with Thurgood Marshall. Thurgood Marshall is clearly on my side. But there was a communications issue. In Michigan, we have arraignment, right? Which is just reading of the charge, appointment of counsel, and setting of bond, like I said earlier, followed 14 days later by what's called a preliminary examination, which is the probable cause hearing, whether they can hold you for trial. Okay. So Thurgood Marshall kept talking about preliminary appearance, and the prosecutor was talking about preliminary examination, which are two different things, but they got confused. And so Marshall was saying, wait a minute, you're telling me, because the prosecutor was arguing, you don't get an attorney at this preliminary appearance. All you do is they read, and you don't have an attorney with you. They appoint one then. And so Marshall said, wait a minute, you're telling me you don't get an attorney at this preliminary examination where there's witnesses and everything? He says, no, that's not what I said. So he's going back and forth with him. And there's one particular point. Well, Marshall says, no, wait a minute. First you say this, then you say that. So what's going on here? Or am I just confusing things again? And you could see Marshall, there was smoke coming out of his ears. And my co-counsel, by the way, there were two cases joined. So the case is reported as Michigan versus Jackson, because Jackson's prosecutor filed petition for cert first. And we were joined they're two different counties, two different murder cases, but we were joined in the Michigan Supreme Court as well. So co-counsel was a long-time friend, and he's sitting next to me, and he said, I think we're winning Marshall. Said, yeah, we got him. And the argument went very well. The prosecutor got reamed. There were two prosecutors, one from Jackson County, my prosecutor. Now, this is where it gets confusing. Jackson County had the Bladell case. Wayne County had the Jackson case. That was his last name, okay? But the prosecutors basically flipped a coin because they both wanted to do the argument. But the court told them only one prosecutor can argue. But since they were petitioner, they flipped the coin. The winner got to do the argument. They did this, a month earlier. The loser got to do the rebuttal. Okay, so they'd both get their time in front of the Supreme Court. Well, Marshall kept my prosecutor up there so long that at the end of his argument, he said, he's trying to answer questions and he's talking even faster than I talk, right? And I know I talk fast. He's talking, just trying to get it out. He's talking like that. And he goes, okay, I'd like to save whatever time I have left for rebuttal. Boom, the red light goes on. Oh, I see I have no time left. And you could see the other prosecutor just go, oh, like somebody let all the air out of him. Because when that red light goes on, that's 30 minutes. You have no time left, not even rebuttal. When the yellow light goes on, there's still 5 minutes left. So what my prosecutor should have done is shut up when the yellow light went on. Then they could have rebutted us, but they had no chance to do that. We get up there to argue. My colleague, co-counsel, went first because he was going to make a more radical argument. And then I was going to follow up with at least you got to do this argument. So I got the easier job. He wanted to do the more radical argument, which was, once the Sixth Amendment attaches, the police should have no right to ever talk to any defendant without counsel present, period. None of this Miranda warnings crap. None of this, if he invites them back like Edwards, they can get a waiver. No, none of that. Sixth Amendment's different. Well, they didn't seem to bite on that very much. They didn't seem to like that. So I get up there and say, look, you got to at least apply the Edwards rule to this situation, just like the Michigan Supreme Court did. It's a very reasonable opinion. It makes all kinds of sense, and it provides them with the kind of protection they're going to need. And when we came out of there, my prosecutor, who I've known for years and is a good guy, he comes out to me, he says, well, no question who wins. The only question is, how many votes are you going to win by? And I said, you don't think it'll be 9-0? He said, nah, don't forget, Rehnquist is on this court. So I didn't get Rehnquist, Howell, or Sandra Day O'Connor, believe it or not. She didn't go for me. But I did get Stevens, who wrote the opinion, and Warren Berger wrote a concurrence because of stare decisis, which cracked me up. Because there was no stare decisis. There was no Supreme Court decision that controlled the outcome of this case. And I even admitted that. It was just his easy way of doing the right thing, I suppose. So sure enough, the opinion came out on, believe it or not, April 1st, 1985 or 86. It's a long time ago, but one of those two. And the TV station in Lansing, Channel 10, serves both Jackson and Lansing. And so the headline that night, I had to watch the news at 11 o'clock to see if they reported on my case, because nobody ever interviewed me. Shouldn't they? Here's how that started. In a surprise April Fool's Day decision, the anchorman says, I said, who was surprised? I wasn't. Their prosecutor wasn't. Who do they interview? His boss, who was an idiot. And he was, I'm shocked. I said, you should talk to your own prosecutor. Just to add a nice coda onto that. Years later, when I'm teaching at Cooley, and I have a brand new criminal law class, and what I would make my class do is fill out 3x5 cards. And I warned them, I use those cards to call on people. Okay. And so I need not only your name, but if you think I need it, or you don't care if I butcher it, give me a pronunciation of your name. Where'd you go to undergraduate school? Where'd you get your degree from? Okay. What degrees do you have? That's just interest to me. And do you have any connection, any experience with the criminal justice system that you're willing to share? Okay. I even had one guy wrote, well, I've been in and out of prison most of my life. So I call on this one guy, Bruce Cruz, nice guy. And he said, and he's from Jackson, Michigan. And he said, my uncle was a prosecutor who argued a case in the U.S. Supreme Court. I looked at him, I said, really? I said, what was your uncle's name? He said, well, Brian Thede. Did your uncle tell you who the lawyer was that he argued against? And the way I'm looking at him, he figures it out. Bruce got like the highest grade in my class. He's a real bright guy. He looks at me, he says, you? I said, yep. I said, tell your uncle I said hi. And I still love the fact that I beat him. The other coda, and this is something you may be aware of. When did you take the bar?
So I took it in 2011.
Okay. So I'm not sure when this came out, but some 17 years later, which would have been right around 2011, the U.S. Supreme Court issued a case called Montejo versus Louisiana. And in that case, Montejo argued initially that the Jackson case did not apply to him, even though it was similar facts, but because of factual differences, right? Trying to distinguish Jackson. And they made it all the way up to the Supreme Court on that argument. And the Supreme Court turned to the prosecutor and he said, well, do we really have to distinguish Jackson? Can't we just overrule it? And the prosecutor honestly gave him an honest answer. Said, Your Honor, neither of us briefed that issue. He said, well, why don't you? I'm going to suggest to my colleagues here that we remand this case to brief that issue. And the rest of them are all nodding their heads, apparently. So they did. And the case went back, and in Montejo, Scalia wrote the opinion. And he wrote that the issue is whether Jackson should be overruled. We hold that it should be. And then he proceeded to say, and this is a quote from the opinion, the Jackson decision is poorly reasoned, is unreasonable and unworkable.
Wow.
So therefore, we got to get rid of it. And one of my colleagues at Cooley, when it came out, Kurt Benson, he taught in the Grand Rapids campus, funny guy.
Was he taught Civ Pro, right? And he had a radio show? Was that him?
Yeah. Did you go to Grand Rapids campus?
No, but he taught a Friday night class, and I loved it. He came for Lansing once.
Yeah, taller, thinner, balding guy.
Yeah, very funny, very articulate, very entertaining. Yep.
Yeah, well, he comes into my office and he says, Bretz, I just read this Montejo case. I said, I know, I'm still getting over it. He said, no, you were a great lawyer. I said, what makes you say that? You convinced the Supreme Court to do something that was unreasonable and unworkable for 17 years. I'm thinking, okay. And he obviously was a joke, But I loved it. And I've always remembered. I've told Kurt the last time I saw him that I still remember that and tell my classes about it. But yeah, that was the highlight of my career. But I know I'm talking a lot, but I don't get to talk about this stuff much. But I want to add something that I have not talked about, except to a few people, because I haven't seen any students. Back in 1985, when I was at Sato, I was assigned to a case involving a 15-year-old boy who murdered his 12-year-old uncle. Now, this 12-year-old was my client's dad's youngest sibling, okay? Dad had a big family. And this was up in Midland, Michigan. Well, my client was convicted. I mean, the only argument he had was that he lacked premeditation because he had blood all over him, there was nobody else there. What had happened was, and I taught this case in criminal law because second look theory with premeditation, okay? Are you familiar with that?
Yeah.
If the defendant has time, if he starts killing without premeditation, that doesn't make it first-degree murder. But if he has time during the killing to reflect upon his actions and take a second look at what he's doing, that can be used to show premeditation. Well, in my case, nobody knows what happened. Nobody knows why my client killed this kid. Okay, back then, nobody knew. And they just knew that he did it. But the pathologist testified that my client hit him, that the victim was struck with a baseball bat and then stabbed with a knife. And all of the wounds were on the victim's left side. And my client, of course, is right-handed. The prosecutor cleverly argued that nobody else was there but the defendant. And at some point, he had to put down the bat because it wasn't doing the job and pick up the knife. That's premeditation. The only argument I had in the Court of Appeals was, no, it's not. The Court of Appeals said, as I expected, yes, it is. Broke my heart. I liked this guy. Clearly, he just flipped. He lost it. But he couldn't get an insanity defense. The most friendly to defendants shrink in the state of Michigan said, nope, he's not insane. He's not mentally ill. He's just lost it. And I liked his mother. So when the opinion came out, I called his mom because she kept regular contact with me. And I said, we lost. And she started to cry. And I said, look, I don't know what else to say. I said, I think the law is wrong. Michigan had a law that required mandatorily, if you're 15 and up, mandatory life without parole for first-degree murder. Mandatory. So at my client's sentencing, his judge, who since died, said, the law says I have to send you to prison for the rest of your life. There is no opportunity for parole. You will never get out. I think the law is wrong. I really do. And I wish I didn't have to do this. For your sake, I hope they change the law someday. And then sent him off for the rest of his life. He was basically told, you're going to die in prison. I called his mom and I said, we lose, but if they ever change the law and I'm still alive, I will get Jerry out of prison. Well, you may know that, oh gosh, it's been almost 10 years now, because I was still at Cooley when this happened. So it's been about 12 years. The Supreme Court came out with a case called Miller versus Alabama. And they held that mandatory life without parole for juveniles violates the Eighth Amendment ban on cruel and unusual punishment. Said, that's my case. I called mom. She hadn't heard from me in years, but I said, I told you, I made you this promise. They've changed the law. I'm going to pro bono. You don't have to pay me anything. I'm going to do my best to get Jerry out of prison. Because I'd kept in contact with Jerry and I knew that he was doing really well. Okay, he went to prison at the age of 15. Now he's 50. 50. He got an associate's degree, a college degree. He's a published author. He worked for the warden, counseling new inmates, doing suicide watch. I mean, this guy was unbelievable. So I called the appellate defender office because they were automatically reassigned all their old cases to do these Miller hearings. In Michigan, the Supreme Court said they can still get life without parole, but only if they're shown to be incapable of rehabilitation, the worst of the worst, okay? So clearly that's not my guy. So it's up to the prosecutor to seek life without parole. If he doesn't seek life without parole, then the judge can sentence him up to 20 to 40 years. I know we're probably way over the limit now. So to cut to the chase, I represented him. Sato gave me backup support, filing help. They assigned a young attorney to work with me to compile information. We hired a shrink. We hired a brain scientist, a neurologist from U of M, who was an expert on the juvenile brain. We had a social worker. We had a prison specialist. We had mom and stepdad testified. And after 3 days in court, now I have not been in court since 1996, other than to say, Your Honor, I move for the admission of so-and-so into the State Bar of Michigan, right? I won all those cases. This is my first time as a real lawyer in 35 years. So, and this just was a few years ago, 2017, I think it was. So right before COVID. So I went up to Midland, did this. I got a good judge, good guy. A fellow MSU grad. So we were a couple of Spartans. I saw his paraphernalia on his wall. So we talked Spartan stuff. Oh, hey, were you at that game last week? Oh, yeah. It was abs. And he got out. The judge sentenced him to 20 to 40. Now, Jerry had been in, from 15 to 50. So what's that?
35.
Yeah. And so he went back to prison after the hearing and went before the parole board, got an immediate parole, has been out ever since 2017, maybe early 2018, he got out, and he's doing great. Got himself his first girlfriend ever because he was 15 when he went to prison.
Yeah.
So in that, I came home. I mean, I was almost in tears when I left the courtroom. No, not almost. I was in tears, happy tears. This was just, I wanted to do this for so long. From 1985 on, I've wanted to do this. So that was, and then I came home, hung up my suit and told my wife, I'm done. I'm never going to put a suit on and be a lawyer again. I don't miss it. I loved it, but I don't miss it. Yeah. Okay.
That is incredible. And what a way that is like Ted Williams-like way to go out.
It is. It really was. I mean, to come in totally unprepared. And I even choked up during my closing argument. I'll tell you one real quick anecdote from the hearing. I had my client on the stand because I wanted the judge to hear him. You don't always put your client on, but he's guilty. He admitted guilt, right? And but he had done so well. And so one of the things I wanted to explore was, when you went to prison, did you believe you were going to die in prison? He said, well, basically, that's what I was told. And, I didn't see any hope on the horizon. I said, and yet you didn't get in any trouble. You didn't get any misconduct reports. You started going to school. You got degrees. You started writing. Why? Why'd you do this? And I just thought because it's not a question we had rehearsed. I just thought he was going to say, well, I knew I was going to be there all this time. I just wanted to improve myself. I figured I had to focus on something, right? That would make sense. His uncle, who he killed, was Nicholas, was his name. So he looks at me in the eye and he says, I did it for Nikki. I said, and I'm thinking, I said, you did it for Nikki? He said, yeah. He said, I didn't want to disappoint him again. I know he's up in heaven or wherever watching me. And I disappointed him in the worst possible way. And it's not even fair to call it a disappointment. It's worse than that. But after that, I did this all for him. I'm like, my brain is saying, holy shit, I can't believe he said that. I'm not a good enough lawyer to coach him to say that, right? Who would think of that? So when I'm doing my closing argument, I said, and Judge, you heard him. When I asked him why he did that, why he bettered himself in prison, accomplished all this amazing stuff, he gave us a 2-word answer: for Nikki. But when I got there, I said, he did it for, and I got choked up. I couldn't get Nikki out. So I finally got it out, and then I quickly wrapped up. And when we were all done and he's leaving the bench, and he said, I'll let you know when I'm ready to issue my decision. And I got a call 2 weeks later, and I went back. I said, Judge, I'm sorry. I got choked up there. I said, I'm too close to this case. I've known this family for 35 years. And he said, don't worry about it. He said, I cry too. He said, I'm a crier. And who did we just hear on the news talking about being a crier? In Michigan State, Tom Izzo, after the shootings at Michigan State, he got up in front of thousands of students at this vigil, and he cried. So I'm a crier too, but I usually cry over sappy stuff, not sad stuff.
And I think I live in Philly now, and he has Bay Area ties, which is where I'm from. The name that comes to mind when I think crier is Dick Vermeil, the football coach. So back to the Supreme Court. What was that like? Because going into it, was the magnitude of the situation lost on you? I would think that most lawyers would aspire, like that's like playing in the Super Bowl, would be to go to those steps, walk in, argue in front of, arguing today, you're talking about legendary figures, but to say Thurgood Marshall to someone like me, that is like a statue. That is like a mythical figure almost.
And Sandra Day O'Connor, who.
Oh, right. Correct. So Sandra Day O'Connor and Thurgood Marshall, so was that all lost on you? Were you too young and naive to realize it, or were there knots in your stomach?
I had an advantage there, and I'll tell you what that advantage was. I started working full-time at the Appellate Defender Office in 1976 after I graduated from Wayne Law School. And in 1977, maybe, so I'd only been there a year, one of the lawyers there got a case in the U.S. Supreme Court. She won a case in the Michigan Supreme Court, and she should never have won. It was a stupid issue, but she did. And the prosecutor filed for cert, and they granted it. And so when you argue in the U.S. Supreme Court, they give you 6 tickets, because if it's a busy day, if they're arguing like an abortion case or something and everybody wants to be in there, the regular crowd, the citizens that come in, the civilians, they're only allowed to sit there for so long, like one case, and then they throw you out so that more can come in. But if you've got those tickets, you get to stay and you get better seats, right? So right away, I offered 3 of them to my parents who really wanted to come, and my wife. The other 3 I gave to colleagues. Well, when my colleague had a case down there, right after I got out of law school, she said, I got 6 tickets. My parents don't want to come. They don't give a shit. She said, you guys want to come? Oh, yeah. So one guy had a van. So we all loaded in his van, drove down there, had a great weekend, but I got to watch arguments. And that made, Thurgood Marshall. And I got to hear the Solicitor General from the state of Michigan, because it was a extradition case. And he said that the Michigan Supreme Court's decision was way too liberal. And if you agree with the Michigan Supreme Court and uphold their decision, you're going to make every one of the 48 states a haven for bail bond jumpers. And Thurgood Marshall leans forward and says, counsel, I think we have 50 states now. The Solicitor General was an old dude. I think it was just the 48 states, just what he learned in high school, and that's what he stayed with. But anyway, so it was kind of funny and interesting, and my friend did a good job. She lost the case, but it was a dead loser. And then a week before our case was argued, The Supreme Court heard arguments in another confession case called Moran versus Burbine. I don't know if that was in your criminal procedure syllabus. It was in mine for a while, and then I got rid of it. But this was the case, you may remember, where the defendant, Gary Burbine, had been arrested and was in custody and suspected of murder. And his sister or girlfriend, some woman he was with, knew that he'd been arrested. So she called the public defender's office and said, help, my boyfriend's been arrested and he's in jail and they're talking murder. So the public defender goes right down to the jailhouse and said, we're going to represent this guy, at least until he hires his own lawyer. We're going to represent this guy. We want to talk to him before there's any interrogation. This was nighttime. She's told by the police department, don't worry, counsel. We're not going to talk to him tonight. If you get here first thing in the morning, you'll have plenty of time to talk to him before we do, right? She leaves. They interrogate him, get a waiver, get a confession. She comes the next morning, talks to him. He says, well, I already confessed. They came to talk to me last night. She is so angry. She goes screaming and yelling and said, so we lied to you. So what? How does that make your client's confession illegal? And the Supreme Court basically said, the defendant has a right to an attorney. The attorney does not have the right to a client. So Burbine lost. But our office, my boss, agreed to pay to send my co-counsel and I down to Washington to watch those arguments. And as members of the Supreme Court bar, we got to sit up close because we had joined the bar by then, so we could argue the case. And so both those experiences helped rub a little of the wonderment off.
The mystique, right?
When we went down there, because arguments were on Monday morning. So we went down on Saturday. We get a couple of days to get acclimated, right? And so Saturday, my wife's brother lived down there. So he came and took us out to dinner Saturday night in D.C. because we were staying at a hotel in downtown D.C. Sunday, we did a little, it was the fall. It was October, maybe early November, but the weather was decent. So we did a little walking around town. My wife grew up just outside of D.C. in Silver Springs, Maryland. So, and she said to me, you're not nervous? I said, no, I'm just enjoying myself. Sunday night, got together with my co-counsel. We had adjoining hotel rooms and we just peppered each other with questions, right? And I wasn't nervous then. I woke up Monday morning. I was so nervous. I slept great Sunday night. Monday morning, it hit me. I got to go over there now. I was second up on the morning calendar. So I said, oh, geez. And my parents were staying in the same hotel. My wife and I got up, went down and met my parents for breakfast. I'm an eater. I love to eat, and I love breakfast. Breakfast in a hotel to me is, a luxury, particularly when they got an omelet bar. They had everything. It was a nice hotel. I couldn't eat. I had a little coffee, had a roll, I think, or some kind of bread product just to sit in my stomach, and then went over and did the argument. But the way it's set up is, and you're told this ahead of time, there's 2 rows of counsel tables. Argument number 1, sit in the front row. Argument number 2, sit in the second row. So as soon as argument number 1 is done and those lawyers have moved out, argument 2, move up to the front row. Okay? So we were right up front. And the other thing that really helped, and I hate to say this out loud, but the argument before us, the prosecutor in that case was, in fact, I see her all the time now on cable news. She's been a commentator on a lot of this Trump impeachment stuff because she was one of the lawyers in the Watergate hearings. Her name was Jill Wine something. Her name was Jill Wine back then. And she was with the AG's office in Illinois at this time during this argument. So she was representing the state, and representing the defendant was a young attorney like me from the Illinois Appellate Defender Office. Okay, one of my people. He was terrible. He wasn't very good at all. He was stumbling and mumbling, and I felt sorry for him. I think the court did too. They didn't hit him with a lot of questions, but you know what? Your very first question is answered by this anecdote. He was bad at oral argument. He won the case. Okay, Greenfield versus Illinois, I think it was called. But he was so bad that I go, I don't care how nervous I am, I'm going to be better than that. And that helped. That really did help. When you see the big hitter on the other team strike out, you figure, I can't do any worse than that. And my colleague went first, and they kind of ripped him up. They went after him because he knew that. He was on the defensive, but he made the radical argument. You can't even approach these guys unless there are lawyers there. And in civil cases, isn't that what the Code of Ethics say? If there's a civil case pending, plaintiff's lawyer cannot approach the defendant unless defendant's lawyer is notified and present. Anyway, they didn't buy it. But I get up there and I say, look, this is real simple. And they said, well, what about the waiver standards? Should we change the waiver standard? Should there be a separate waiver standard? And that's the other thing my co-counsel was arguing. There's a case called Ferretta versus United States. And Ferretta waived his right to an attorney at trial. And the U.S. Supreme Court said, waiving your right to trial counsel is a big, big deal. So in order to obtain a waiver, it has to be done in open court, on the record, and the judge must advise the defendant not only of his right to an attorney, but of the dangers and disadvantages of proceeding without counsel, right? And that was a Sixth Amendment waiver case. So we argued to waive the Sixth Amendment right, even for a confession, the defendant should be advised by a judge of the dangers and disadvantages of proceeding without counsel. So that's what he argued. And he said, what about those higher waiver standards? And I said, well, here's the thing, Your Honors. This court has never clearly defined waiver standards for the Sixth Amendment right to counsel in the interrogation setting. This court has only decided 3 Sixth Amendment right to counsel interrogation cases. At the time, they had only 3. Messiah, and this is exactly what I said to the court, this court has only decided 3 cases, and none of them involved waiver. All of them, this court found a violation of the right. So it never reached the waiver issue. Messiah, Henry, and Justice Stewart, or Justice White. Justice Potter Stewart wasn't on the bench anymore. But Justice White, Whizzer White, we called him, because he played football for University of Michigan. Justice White says, Brewer. Real quietly said, Brewer, thank you, Justice White. Messiah, Henry, and Brewer. Both were the cases. So I had a brain fart. But other than that, I thought it went really well. And we left there, and I'm telling you, we went to lunch. My parents chose not to join us because they could see I was with all my friends from the office. So there were like 8 of us. And we found this French restaurant. We went to this French restaurant for lunch. And I think the 8 of us went through about 3 bottles of wine. I had a hell of a good nap that afternoon.
Yeah, that's got to be a heck of a release, And,
yeah. And after I won the case, and because our office at the time had only 3 U.S. Supreme Court cases, and we lost all 3 of them. Mine was number 4, and I won. We won. Now, interestingly, number 5 in that group, number 4 was before mine. Number 4 was John Nussbaumer's, Dean Nussbaumer. When he was still at Sado, he had a case that went to the Supreme Court. He had won it in the 6th Circuit, okay? Went to the Supreme Court, but they only had 8 justices at the time. Somebody must have died or left, but they only had 8 justices. So the vote was 4-4, which upheld his victory in the Sixth Circuit, right? A tie vote in the Supreme Court means the lower court wins. But I still would tease Nussbaumer when I won my case. I'm still the first lawyer to win. You didn't win in the Supreme Court. I won my case, but not in the Supreme Court. Nussbaumer and I went way back. A couple of good Germans. You know, his dad was an assistant coach for the Cleveland Browns.
Wow.
His dad played for the Lions for a while. Bob Nussbaumer. He was a defensive back.
That is impressive.
Yeah. Yeah, you know, but because when I first met him, I said, Nussbaumer, didn't he play for the Lions? That was my dad.
So let's fast forward a little bit. Let's talk about your experience as a professor at Cooley. What year did you become a professor?
I want to say 96. I think I started in the fall of my first term, and I never got those Hillarys and Michaelmases straight. It was fall, winter, and spring. I started, I think, in May. So it would have been Hillary term, the summer term. I started in May of 96. That would have been my first term, and I taught 2 sections of crim law, both of which were at night. So isn't that true? Yeah, the summer students started at night. And then in September, I also had criminal law. In January, I moved to criminal procedure, January of 97. And that would have been the Flanagan class. So the first class that I taught when they graduated, which would have been the Flanagan class, who were second-year students in 97, they graduated in 99. And they were great. I mean, I still have close friends from the Flanagan class. One of them became the keyboard player in my band until he moved away. I was in another one's wedding. I did a reading at another one's wedding. And I'm still friends with a lot of these people. And so when they graduated in 97, at graduation, when they announce the Beatty Award, favorite professor, the professors don't know in advance. So we kind of find out right then, you know, and the winner of this term is Ron Bretz, Professor Ron Bretz. Oh, cool. Basically like my first year of eligibility for the Hall of Fame, right? And you get up and get to say a few words. And, it's all extemporaneous. But flash forward now to 2013. And I had 2013 is when the axe hit the Cooley faculty, right? Almost 2/3 of the faculty was let go in 2013. And I had already taken an early retirement. So then Cercone calls me at home. I'm gone from Cooley. I haven't taught there for a whole semester or for a couple semesters. And he said, well, this year's graduating class, I don't usually tell people this in advance because I'm not supposed to, but this year's graduating class voted for you for the Beatty Award. I said, really? He said, yeah. And so I'm just calling to see if you want to come to graduation to get it in person. I didn't even hesitate. I said, hell yes.
What year was that?
2013, I think.
Okay, because you spoke at my wife's graduation, which was in 2011 as well. I was there for that. May of 2011, I think.
That was not after the merger with Western, was it?
No.
Okay. Yeah, because I won it like 5 or 6 times. But this would have been the last time, and you would have remembered this one because when I told Cercone, sure, I'll come and get it. He said, oh, great. He said, I was hoping. I told Henke, oh, great. I want Bretz to come because he'll say anything. He wanted me to say horrible things. But I looked out at those graduates and their parents. I said, I'm not going to be bitter or angry up here, but if I can make fun of things, I will. So, and, I sat on that stage like we always do. And you may remember your wife's graduation. There were probably 40 professors on stage?
Yeah, there's a good amount.
Yeah. At this one, there were maybe 20. And there was a big banner behind them on the wall that said, Western Michigan University, Thomas M. Cooley Law School. So I'm looking at that. I turn around, look at that. And first thing I say, they're all clapping, of course, the students are. And I say, wait a minute, there might be some mistake. I don't work there anymore. They all laughed. And I said, but there have been big changes to your law school. And you can see it right there on stage. You got half the faculty, but twice the name. And they all clapped up. But then I got there, I said, it's sad what's happened. A lot of my friends, a lot of your favorite professors have lost their jobs and are no longer at Cooley. And so I held up this big ass trophy. This is for them. They taught me a lot. I hope they learned something from me. I hope you learned something from me. I learned a lot from you. Slang. One of my students years ago taught me how to text. My kids wouldn't even teach me that. Dad, you're told to learn how to text. But yeah, so my first year was in the 96, 97.
So let me ask you this. Did you teach any of our, I guess, famous or infamous alumni? So I think of the Congresswoman or Mike Cohen or the Lightning coach, John Cooper, any of these people?
No, Cooper and Michael Cohen. You knew Michael Cohen went there, right?
Yeah, that's why I said infamous.
They were way before my time, but Rashida Tlaib was in my class.
Oh yeah,
Rashida?
Yeah.
No,
she was.
Yeah, she was in my class. I didn't really know her well, but she was in my class, and she was always challenging things like she is now. It's kind of funny. When she was running for election or re-election, I think, and a hidden camera caught her at a banquet talking about Trump and using an extreme obscenity for to Trump. We're going to impeach that MFer.
Yeah.
All over the country, people are they're just wringing out their handkerchiefs and they're in a tizzy about this. And in Detroit, we're all going, that's how we talk here. Big deal. I'm sure it's the same thing in Philly, right? That's how we talk here. Nobody's going to go nuts over that.
Yeah.
But yeah, and I taught a few students who are in Canadian Parliament now.
Okay.
I think it's kind of cool.
And there was a girl that was a few semesters behind me that I think is a Texas state representative or something like that.
Oh, Jessica Gonzalez. Yes.
Yes.
One of my students. And she's a fascinating woman. She is brilliant. She's openly gay and obviously a Latina. And she represents a poor Latino area of Dallas. And so she's pretty safe, but she doesn't hide her sexuality. Didn't at Cooley, and just brilliant. And some other people. We've got a lot of judges now, and so a lot of my former students are judges. One of my former moot court students, Cassie, what the heck was her last name? Cassandra, she goes by now. Cassie isn't good enough. She's a judge up in Northern Michigan. I got another judge up in Northern Michigan. This guy, David Fleischer, who was in that Flanagan class in 99. I
think I had her for trial. Was she a Cooley grad? I think O'Neill.
Oh, Julie O'Neill. She's a judge now in Eaton County. Yep. She was not one of my students, but she was a student when I started. But she was an upper termer when I started teaching. And, I taught first and second termers pretty much, first and third termers. There's more. Carla Baldwin in Ohio. So all over the place, we have grads in high places. And we also have grads in low places, I suppose. But yeah, John Cooper. Now, you talk to the old timers, and I mean the old timers. I talk about people like Ernie Phillips, Otto Stockmeyer. You probably never had any of these people as teachers.
Stockmeyer was teaching when I was there, but I didn't have him.
Well, Stockmeyer knew Michael Cohen. And so only one of the old timers remembered Cohen. He said, what I remember about him is that he was into the taxi business in New York, and he made a lot of money. He was paying his own tuition with that money. And I found he explained to me how the medal system worked, how you have to buy a medal to be able to buy a taxi. And when Michael Cohen started getting in all this trouble, they started writing articles about he and his family buying up these taxi medals. It's still a bizarre system. I don't know if you know what I'm talking about.
I know exactly what you're talking about. And that's kind of how Uber was able to disrupt everything, right? Because, and then the taxis got mad. Wait a minute, all these regulations and these guys aren't, but yeah.
Yeah. So, but it does please me to no end. I mean, this Cassandra, her married name is now Green, but I forget her name when she was at Cooley. And she's now the circuit court judge of Alpena County. She's the only in circuit court in Michigan. That's the trial court. That's the felony and major lawsuit court. District court is where Julie is a judge in district court. That's a lower court.
Gotcha. So what would you say was unique to being a professor at Thomas Cooley Law School as opposed to another law school?
Oh, it's an easy answer, and everybody will give you the same answer. And it came up during my interview. Dean Timmer, Amy Timmer, was in my hiring committee. And she's, at the end of the interview, they always ask you, do you have any questions for us, right? And I said, yeah. And what are you looking for? I said, now that I've already told you everything about me, now I'm going to ask you, what kind of person you're looking for? And Timmer, without hesitation, answered, we're looking for somebody that can teach our students to be good practitioners. Scholarship comes second. And we're one of the only law schools in the country that believes that. I said, really? And at the time, she was telling me the truth. And the law schools, and let me give you another little story. When I got the job, I was so excited. And I told a bunch of my lawyer friends who had gone to various law schools. None of them had gone to Cooley. Most of them were older. I'm the age of the very first Cooley graduating class, 1976. That's when I graduated from Wayne Law School. So my friends all graduated 76 or even earlier. And I'm talking to them, and I said, yeah, so you're going to be a law school professor. I said, yeah. He said, that's great, Ron, but I hate to tell you, the worst teachers I ever had in my life were my law school professors. Worse than the nuns I had in grade school. And I said, you know what? That's true for me, too. I had some good teachers in law school, but man, I had some of the worst teachers you could ever imagine. They didn't give a shit whether you learned anything. They would stand in front of the room and mumble. They would hold up visual aids in a class of 100 students that were photographs this big, and then put it down and expect us to know what they just showed us without kidding around. They were serious. They were idiots, but they were geniuses, right? The idiot savant. They wrote books. They wrote scholarly papers. They graduated from top law schools. They clerked for federal courts. They never practiced a day in their lives, and they lacked the ability to communicate with ordinary people. Now, this is not universal, okay? But this is true, and particularly at schools like the hotshot schools. And that's not me, right? I don't care how many angels can dance on the head of a legal pin, all right? My scholarship, which I had to do to get tenure at Cooley, was basically practical scholarship. I wrote criminal appellate summaries lectured on them to criminal defense attorneys and would write articles in the Journal of Practical Law that Cooley had. I would write articles on that would take my summaries and weave them into an article. No, the court did this. This was a problem because, I'd criticize the court's opinion. Occasionally I would try to be funny and my editors would get rid of it. I was talking about a case once where there had been a drive-by shooting earlier in the day in this terrible neighborhood in Detroit. And then things settled down. And so some guy across the street's out there washing his car. It's a beautiful day. Well, the guys who had done the drive-by shooting earlier, they come driving past that same house again, just to see if they'd had any luck. Well, the guys inside the house that had been shot at start shooting at these guys in the car. The dude across the street washing his car gets killed. All right. And it was a case of transferred intent. It was pretty straightforward. But I wrote in the article, in a fascinating view of dispute resolution in the urban setting, get rid of that. He said, it sounds kind of racist. I didn't say I don't know what race these people were.
Right.
But I'm sorry, where did that come from? Where did that answer come from? Oh, yeah. So the interesting thing was the practical nature. And Cooley made every effort. When I say Cooley, I mean the administration, the dean of students, made every effort to make use of my practical experience. As soon as I got there, they said, Bretz, we want you to do moot court. I said, well, I was an appellate lawyer. I guess that makes sense. Yeah, so I did. I did moot court, and I ran the moot court program until they hired a former Supreme Court clerk and another full-time appellate lawyer, Evelyn. She was named Evelyn Tombers when she was hired, but then she got married and changed her name to Evelyn Calogero. I don't know if either of those names mean anything to you, but she ran the moot court program. Okay, because I was teaching 2 courses. She taught research and writing and ran moot court. And so every year, there's these various competitions we would participate in. And I had to get coaches for all the various teams. That's what I did. And that was the thing that at Cooley really struck me. And so we graduate, and most of our graduates really go on to practice law. They really do.
Yeah. I mean, so you're number 10 in this line of, I've had 9 people before you, actually 10, because I had Ricky and Renee Diaz, who were a married couple. They came on together.
Yeah, they were students of mine. And I joined Facebook when I was at Cooley because students asked me to, and because graduates had asked me to. And I said, okay, but I'm not going to friend you. You got to friend me. I don't friend anybody except my daughters. Because I want to know. I'm learning from friends what my daughters are doing. So they did. But so Ricky and I'm drawing a blank already. Ricky and Renee are Facebook friends. Manish is a Facebook friend. Shane Scott is a Facebook friend.
And they were teammates on your Crim Pro moot court thing, right?
They went with me. They were on the same competition, but Manish's teammate was a Pennsylvania guy, a big dude, Mike Assant. OSS.
Okay.
I
remember him. Mm-hmm.
Yeah. I'm Facebook friends with him, and he's looking pretty slim, looking good. He wasn't strong, but he had a lineman build, a football lineman. Okay. And then so he was, and Shane's partner was Aaron Rodenbohl.
Okay, yeah, I remember him.
Yep, he's still here in Michigan. The rest of them have, because Shane was from Michigan. They were both Michigan people, but Shane's from Detroit. I met her parents; they're wonderful people. But she did an externship in New Jersey. Decided she loved it there and stayed. And she's doing well, isn't she? Like a partner now. Yeah,
she made partner. She was my first guest. I got really good feedback about her episode, and she argued before the New Jersey Supreme Court and was telling her story about that whole experience. And then I think after we recorded her episode, she got admitted to the United States Supreme Court. So, yeah, she's continuing to do big things.
Oh yeah, I love those people, and I would give nothing to see them. I would give everything to see them again. Munisha and Eddie. She's married to.
Yeah,
Cooley.
They were both friends of mine in law school. Yep.
Well, that's right. They met in California, in fact.
Mm-hmm.
Eddie Lara, and just what a sweetheart he is.
And then Christian, who was one of my guests, you participated in one of his fundraisers, right?
Right. Gave him some money, and we did a Zoom fundraiser. What was he expecting? He's a young lawyer running for attorney general in a conservative state. But
he put up a respectable numbers, and he was on and he shared his story. And COVID took a hit. He gained a lot of momentum at the end, but COVID definitely impacted some of what he was trying to do. So.
Well, but it is true that lawyers who run for judicial positions or attorney general positions or prosecutor positions and lose, they get their name out there. And as long as the name goes with all good things, nobody comes out and says, oh yeah, but he kills dogs, he eats cats. There's nothing horribly scandalous there. People remember that name. Oh, Christian Y. Smith, particularly, right? Yeah. Assume the Republican who beat him was a white guy or a white person. So among the Black community, people are going to say, hey, this is a stand-up dude. And that's the image you want to present to your potential clients. I'm a stand-up dude. I'm going to stand up for you every chance I get. What kind of work do you do?
So I do, I just recently opened up my own law firm. I had a guy named Professor, and I was actually going to write about to bring up a quote that he always would say.
What's the quote? Let's see if I can guess who he is.
Professor Burleson?
Oh, I was going to ask you for the quote first.
Well, his line was, because he was telling us, if you're going back, and his quote was, run for office because the worst thing that could happen is you win. And he was saying that.
I wouldn't have guessed Bert from that, but that sounds like
he was saying that for the exact same reason of what you're saying. He's like, your name's going to get out there. It's going to, it's going to do other things, open up other doors. You're going to meet all kinds of people that you might not have met otherwise. And that's why it was a plus. But yeah, so, I took a summer off and worked at a bankruptcy firm in Cincinnati. Actually, do you remember Ron Janis? He was
yeah.
So he ended up getting me a job at this firm in Cincinnati. I worked for two wonderful women at a small bankruptcy firm. Learned a little bit about bankruptcy, and then it kind of planted the seed that I eventually wanted to go out on my own. So I graduated past the bar. I worked at a bank and did all sorts of things in the mortgage company, foreclosures and compliance and risk and all that good stuff. And I wanted to start my own firm before I was 40. So I took the areas that I had a little bit of experience with, which was bankruptcy, both on the consumer side as well as the bank side, divorce, and some criminal law. I did the clinic at Cooley, which was a phenomenal experience.
Terry Kavanaugh?
What was that?
It's Terry Kavanaugh?
Yes.
Oh, yeah.
He was
a great guy.
He was a great guy.
He's still alive.
Yeah, I meant to say he was a great professor. That's what I meant to say.
One of my, probably of all the people I taught with at Cooley, he was my closest friend.
So that's great to hear. And he invited us to our house after the clinic for like a party. But I really look forward to.
I showed up at a number of those. I don't know if I was there at the one you were at, but because I just lived down the street from him.
Okay, I don't know if you were there. I know Professor Swedlow showed up.
Yeah.
But yeah, I mean, Professor Kavanaugh and I, we got along really well. We both like baseball, and but yeah, he had this clinic, and that was an amazing experience. But then we had this mandatory class every Thursday night, and basically got to share war stories and hear what other people had to say. And it was really good. That's when I felt like I was going to be a lawyer, and like what it was like, in the trenches. Mm-hmm. And one of our colleagues had an incident that became a topic on SNL. So I guess someone called 911 because a person was strangling a bird, a parrot. So it made the weekend. It made the Weekend Update, and Amy Poehler does this thing where she's like saying, "Hello, 911, what's your emergency? I'm strangling a bird," and then I'm strangling a bird, and it was hilarious to see, something my classmate was doing on Saturday Night Live.
Because it has made the news, and they found it in a news.
Yeah.
Who was the guy in the class who did that? You remember?
I think it was Jenna Rogers was involved in that case. I don't remember specifically, but I think it was her. Or it might have been Michelle Bryant. I don't know.
Both names are very familiar. Is Michelle Bryant African-American?
Yes.
Okay, I knew her. She was in my class, yeah.
Yeah, she was sharp.
Yeah.
I lost touch with her. I know I was Facebook friends with her, but I think she was on her own, started her own practice for a while. So I missed you both times for criminal, but I had an adjunct professor for criminal law. It was Professor Bloomer.
Oh yeah. I hired him. I liked Bloomer. He had a lot of experience. Totally a prosecutor. He was a prosecutor right down to his toes. But I was encouraged by Dean Nussbaumer to hire him because he said, this is before we had Corbett. The first time I heard Bloomer, he said, look at the criminal law department. You're all defense attorneys. We got to get a prosecutor in here. So he and Corbett full-time.
So Corbett I had for criminal procedure, and I loved him, actually.
Yeah, Well, Corbett's a great guy. Yeah.
Yeah, I always said he reminded me of, I imagine him as a professor was like playing for Pete Carroll. He was calm and intense at the same time, and you'd go up to ask him a question and he'd get all fired up. But I still remember I did the Wong Sun case, the fruit of the poisonous tree doctrine. And I remember I just prepared really well for it. And I don't know, he asked me all the questions, and it was the one time that I knew which question was coming next. It was like I was a step ahead of him, and it was just such a great feeling. But that's one of the memories I have from his class. Yeah.
Yeah. Oh, that's cool. Yeah. He's great. I hired him too. I was chair of the department, so I hired him. I hired Swedlow. I hired Tanya Kraus-Phelan, who ran the Grand Rapids criminal department. All good people, just great people. Swedlow actually moved to Cincinnati. Become a deputy clerk for the Sixth Circuit. I used to say to my class, the Sixth Circuit sits in Cincinnati. Say that 6 times real fast. But she hated it. Her husband teaches at MSU. So it became kind of a weekend commuter thing for the two of them. So they didn't sell their house here. So she moved back. She quit her job. She hated it. I saw her at a criminal defense attorneys conference in the fall that I spoke at when I saw a bunch of my former students. And she was there. I said, what are you doing here? You're supposed to be a sensation. I said, no, I quit that. I moved back. She works for Sato. She runs what's called the Legal Resources Project. In other words, she's Sato's answer person for defense attorneys outside of Sato. So if you're a trial lawyer, right, you're on your way to trial, and this happens to all of us. Everything's going through your head. You're driving to court. Everything's going through your head. Okay, then, shit, what if this comes up? I'm going to need a case on that. Oh, you call Kathy Swedlow. I need a case that I can argue this with. She'll say to you, are you heading into court? Yeah, I'll probably be in the courtroom in about 10 minutes. I'll text you in 15 minutes. Right? That's how that works. It's a great gig. And it's grant funded. And she's paid a salary to do that. So, and she's smart. She is way smart. I used to say to myself, looking at these people, I said, why do I feel like the dumb guy in this room? No, I'm not dumb. But my daughter went to law school. Speaking of Pete Carroll, talk about famous Cooley people. Let's talk about Justin Brooks. When we get out this call, Google Justin Brooks, just like it sounds, California Innocence Project at San Diego. He had, and it's just like the Innocence Project that Norm Fell set up at Cooley, that Marla Mitchell Sisson now runs. You get hundreds and hundreds and hundreds of letters from inmates or their families. Oh, he's innocent, I'm innocent. And you get all these students to go through the files, and unless something strikes you, you close the case, right? Or there's a possibility of DNA. And that's what Cooley's always been. At any rate, Justin gets a call one day from this fellow who says, well, I already did my time. And he said, well, we're trying to focus on people who are incarcerated. He said, but wait, you got to hear my story. And the long and short of it is, his story is he went to high school in San Diego and was all-state linebacker, high school linebacker. I mean, he was like one of the best in the state. Pete Carroll, who was at that point head coach at USC, offered him a scholarship. Free ride, you're on my team. His senior year, this was after football season, but during his senior year of high school, one of his classmates accused him of raping her in a deserted stairwell in the school during the school day. He denied it. He's never been in trouble in his life. He's a model student. He's a good guy. He's got a girlfriend. He gets a shitty public defender, quite frankly. And I like public defenders. To me, public defenders are better than most other court-appointed attorneys because that's all they do. We live, eat, breathe criminal defense. And it's a shitty public defender who tells him, look, you got two choices. Go to trial. She's going to testify against you. You have no defense. Her word's going to be your word every time. And you're going to get 25 years because that's what the sentencing guidelines are. If you plead guilty, the prosecutors agreed to a 10-year minimum. He's not going to do it, but finally, he wears down, he pleads guilty. He does 8 years, gets paroled. He's on parole. He's wearing a tether. He gets a Facebook friend request from his supposed victim, or as we defense attorneys would call her, the complainant. And she tells him, I'm so sorry. I'm so sorry for what I've done to you. And I apologize. And, I know this, I lied, but I can't go back on my lie because we sued the school system and we'd have to give that money back. And we can't do that, meaning her and her mom. And so the guy, the defendant, whose name is Brian Banks, he said, with this Facebook post, can't I do something with this? And all lawyers told me, you don't even know it came from her. This could be somebody pranking her. And he thought it was a prank too. So he answers back. If you're going to apologize to me, you have to do it like a real human being and do it to my face. And I don't trust you after what you've already done to me. So I want you to do it at my brother-in-law's office. His brother-in-law was apparently a private detective. She met him there. He secretly videotaped the whole meeting where she said, I lied. You never touched me. I was never raped. But I can't say that in a courtroom because we'll have to pay the money back to the school system and we spent it. It's like $1 million they settled for. A lot of money. So he takes this to Justin and Justin says, that's not evidence. If she won't adopt that statement in court, it's not evidence. It's hearsay. And he said, it's right. I'm not guilty. You got to do the right thing. You got to do the right thing. And he really, really wears him down. So finally, Justin says, okay, goes to the prosecutor's office. This is San Diego prosecutor's office, who he's dealt with many times. And they say, oh, come on. He says, but wait, watch this video. They do. Prosecutor said, I believe her. Now, she lied. but he's out of prison. I'm like, Justin says, he's still on parole. Prosecutor says, I'll agree to dismiss the case. The prosecutor did the right thing. He didn't have to do it. So they get him in there, dismiss the case. Justin is so excited. He calls me and tells me about it. Well, it became a big case nationally, right? Brian Banks, my wife and I are driving one evening, going out to dinner, I think, and we're listening to NPR, All Things Considered. And Brian Banks is on for an interview. I said, oh, turn it up. That's Justin's client. And he's on there by himself. And they said, so where were you when you heard the news? He said, well, my lawyer, Justin Brooks, called me and told me to come down to his office. I said, what? This is a decision, right? You got to tell me one way or the other. He says, I want to tell you in person. So he says, oh man, that means either really bad news or really good news. Come down to my office. So he comes down to he said, I went down to Justin's office, took my girlfriend with me because I needed the support, to hold me if I fainted. And I sat across the desk from Justin. He said, the prosecutors agreed to drop everything in your case. You're off parole. And he said, I am. He said, at that point, Justin handed me a pair of scissors. He said, cut it off. So I gave the scissors to my girlfriend. She took the first cut. Then I let Justin take the second cut. And then I cut it all the way off. And the reporters interviewing said, I mean, just like the basketball team that wins the big tournament game, cutting the net. He said, exactly. And then, and this is, we're crying in the car, my wife and I, we're getting all teared up. And then Pete Carroll, who's now coaching Seattle, contacted him because he'd heard about it on the news and he remembered him. And he said, are you still in shape? And Brian said, I've been working out every day. I worked out every day in prison because that's the only way I could deal with the fact that I was there on a, bogus thing. And I've been working out since I got back. He said, I still got the same speed I had. And he said, can you get yourself up to Seattle for a tryout? Preseason workouts were going to be starting soon. He went up there. Carroll said, I'd love to put you on my team. You got great skills, but I got a lot of linebackers. And I don't see you in any position to bump them. But Carroll made some phone calls. Atlanta took him on. Atlanta took him on as a linebacker, and he played in all three preseason games before Atlanta cut him. But he said, that's okay. I made my dream. Now, final chapter, they made a movie out of it. And the movie it's online, it's streaming. Watch it. It's great. It's called Brian Banks. Simple name. And Justin, they use all the real names. Justin Brooks, my buddy, close friend of mine, he plays guitar. That's how close he is. He's played in the movie by Greg Kinnear. Now, do you know who the actor Greg Kinnear is?
No.
If you Googled him, you'd recognize him. He's been in a million movies. Trying to think what he was most famous for. But you'd recognize him. And Brian Banks is played by this guy named Aldous Hodge, who is also becoming quite the big movie star these days. And Justin, my friend Justin, has a brief cameo as a bartender. But they don't give him any lines because apparently if they give you 5 words to say, then you're automatically a member of the Screen Actors Guild.
Oh, wow.
But watch the movie. It is terrific. And I think Justin, for all the faculty we've had come and go at Cooley, he was hired at 37 to be a professor at Cooley. That's why he's still working and I'm not. He was hired before me. And he taught Crim Law and Crim Pro. Yep. That was a very cool thing. Although Cooley never comes up in the movie, just saying Cal Western, because that's where he was teaching. Cal Western's Criminal Innocence Project.
Gotcha.
He's gotten a lot of people out of prison. A lot of people.
Yeah. Someone told me this story once and I don't remember who it was that took part in the Innocence Project, a story of someone getting freed after all these years and then going to the bathroom and then washing their hands and being all confused and not knowing what to do because there was sensors under the, that spray out the water, and that had not been invented when they went into jail.
Right. That might have been indirectly from me, because I told my class about that.
Okay.
I'd been listening to the radio, and they were interviewing this guy who was a Michigan guy from Michigan, but he was in prison in Oklahoma, and they get him out because he's found to be innocent. And so the family goes to pick him up. They get him out of prison, take him to the airport to fly back, and he goes to use the John at the airport, and he looks at the sink and there's no handles. And so he's just standing there. I want to wash my hands. And he sees the guy next to him do that bit with his hands. He says, oh, okay. He says, because they had computers in the prison. He knew about cell phones. He didn't have one, but he knew about them, mainly because everybody in the prison wanted one. But that was too weird for him. I wonder if it was Shane or one of those people who told you that story.
Probably. I studied abroad with Shane, so there was lots of times for discussions and things like that. So probably was.
Any other questions on your list?
I guess one other question. You were one of the professors that was you'd mix, like you would hang out with your students after class. You'd play in your band.
Yep.
And there were a couple other professors that were like that. Was that discouraged at Cooley, or was it something that was allowed? And is the reason that it was maybe okay because there was anonymous grading?
Yep. And that was a big deal. That was a big part of it. I'll tell you, when I first started at Cooley was right after the Detroit College of Law moved their campus to Michigan State's campus. Okay. Because the Detroit College of Law's building in Detroit, which they wanted to stay at, was kind of basically, what's the eminently domained to build our two new stadiums for the Lions and the Tigers. So they lost their school. Michigan State, who's been wanting a law school forever, but the legislature wouldn't give them the money for a public law school, because you already got Cooley in town. Cooley's private. We didn't have to deal with the legislature. So the legislature wasn't going to give Michigan State one, so they said, we'll just adopt a private one. So Detroit College of Law became a private law school on Michigan State's campus. Well, over the years, that gradually morphed. So they were initially just called Detroit College of Law. Then they became known as Detroit College of Law at Michigan State University. Then they just became known as Michigan State University College of Law, right? Even though they're still private and they cost as much or more than Cooley. They're not as cheap as like Wayne, the public school that I went to. But students were anxious to shed what they perceived as the Cooley name. All right. Now, let's face it. Many students came to Cooley, not all students, many came to Cooley because they couldn't get in anywhere else. Terry Cavanaugh likes to say, Cooley's a law school for the people who partied too much in undergrad. And that's true for some. Some of our students, the better ones, were students who took the bribe, took our honors scholarships, right?
Yep.
And but you take some of our students. We had a guy graduated number one in the class who barely got in, couldn't get in anywhere else. But he would play piano. He's the one who played piano in my band. Dan McCarthy was his name. He now runs the appellate division at one of the biggest law firms in Michigan. And he clerked for the Michigan Supreme Court. He graduated number one in the class at Cooley. And he almost flunked out of Western Connecticut University. Okay, we're not talking UConn here. Because he had to work his way through college. To do that, he played piano in bars and restaurants in New York City. He would drive down there, play a gig, drive home, get home at 2 or 3 in the morning, and get up for class at 9, never do his homework. This is undergrad. So when he got to Cooley, he stopped playing gigs till I roped him into it. But we played easier gigs. But be that as it may, I got a piece of advice from 2 of my old friends at Cooley, two separate pieces of advice. One female who had worked with me at Sato, Passman Green. I don't know if you knew her. She taught contracts.
I didn't have her, but I knew who she was. Yes.
She said to me, let me give you one piece of advice. Don't drink with your students. Even if I have a beer with my students after class someday, just don't do it. It leads to bad things. Okay. Nussbaumer, who was my direct supervisor, he was the dean of faculty, right? I said, and this is where Michigan State comes back into the story. I said, I know that some people might think this doesn't look good to have one of the professors, playing in a rock and roll band and inviting his students to come to the gig. And he said, no, I want our students to feel good about being at Cooley. Detroit College of Law at MSU has stolen so many of our students because what they did was they started a first-year class here in Lansing. So all the students at DCL were brand new students, right? They only had classes in September. All new students started in September. And so they said, we won't interfere with Cooley. We won't steal your students. They promised their board of trustees they would have so many butts in the seats by that January. Well, they didn't. So they decided to start a second-year class in January. Well, where are they going to get students who are ready to start their second year in January? From Cooley. In 1 year, they took 95 students from one class. Right?
Wow.
So we were in competition with them. Everything they did was totally legal, and I probably would have done it if I was them too, right? But we had to compete. And Nussbaumer said, what you're doing over there, we were at the Exchange, right? Walking distance from Cooley. What you're doing over there one night a week, he said, it's a nice thing for our students. I said, and I keep an eye on them. I've had to give students rides home. I don't want them driving in that condition, and he said, no, I'm all for it. Go ahead. Because we'd go on moot court trips, and some of those moot court trips, ask Manisha when you interview her. If Professor Bretz kept up with Dr. Vadgama drinking martinis. Her parents came down from LA where they lived and met us in San Diego. They watched the arguments that night, and her parents were lovely people. Her dad's brilliant. And not only is he a practicing physician, but he teaches at the UCLA Medical School. And so then we go out that night. We have dinner and drinks. And her dad asked me if I like martinis. I said, vodka martinis? He said, me too. What kind of vodka you like? I said, good vodka. He said, 2 Grey Goose martinis for my friend and me. We have one. 2 more. 2 more. Another one. We have 3 martinis. I never have more than 1 martini ever in my life. We got to walk back to the hotel. We say goodbye to them. He's fine. I'm trashed. The only thing I remember about the walk back to the hotel is Mike Osant, Big Mike, right? I jumped on his back and told him to carry me. See if she remembers that. But other than that, hey, we're on the road. But there was certain things and there's, something else that was going on. And this is something that became more of a concern. About halfway through my tenure at Cooley, some things had come up that some of the professors at a faculty meeting, brought up the issue of fraternization. And I don't mean having drinks with students. I mean opposite sex.
Right.
Is it ever appropriate? And the thinking at Cooley had always been, as long as they're not in your class and are never going to be in your class. And, nobody's cheating on anybody. I mean, we're not talking that. We're talking 2 single people. So, and at the time, there were a number of professors who were married to former students. Okay? Very happily. And one of them that students would sometimes ask me about was Disa.
Yep. I knew you were going to say that. Yep. Uh-huh. Is that true?
Well, it's true, but it's not true. In other words, she was Mary Phelan when she started teaching at Cooley. And there's Tanya Krause Phelan, but there's no relation there. They did not involve the same person, the same husband. But Nick Disa, they're both good friends of mine, but Nick had Mary for civil procedure. And he remembered her from it. And so after he graduated, right on the corner there, across the street from Cooley, if you drew a line south from the Temple building and west from the office building, that corner across from both of those used to be the Capitol Lounge. There was a bar there, kind of a low rent bar. That was the Cooley bar hangout. I mean, it was like 100 yards from the school. So, and Nick's graduated and he saw Mary there with a group of faculty having an after work drink. And so he walked up to her and he said, "Hey, weren't you my Civ Pro teacher?" And she said, "I've had a lot of students. You look familiar." He said, "Nick Disa." He said, "I graduated a year ago." And he said, "Oh, okay." Well, they started dating then. Okay. So they're out of school.
That's fun. So I'm glad you brought that up, because that completely dispels, what you can imagine students were saying.
Yeah. And I because I knew that story before, because I knew Nick for so long. Nick worked at Sato for a while. That's when I first got to know him, when I was still at Sato. But anyway, there are other examples. My favorite is we've had professors get married. John Marks.
And Dina Marks.
Dina, yeah.
Yeah, so I went. They were our chaperones. They had the greatest gig on earth in Australia. He had to teach one class and hang out with us, and both really, really good people.
Oh, they're really good people. I agree with you completely.
They also invited us to their house, sort of like a reunion type thing.
Well, I used to do that every summer. We'd have the first year moot court competition. And I was in charge of that. It was the criminal procedure competition. And it was for Crim Pro students only. You had to be currently enrolled in Crim Pro, and it's strictly voluntary. It's held on a weekend. And most of the competition is, I think, it turned out to be Saturday afternoon and Saturday night, maybe Friday night. Anyway, it was a weekend night is when most of it happened. I think it was Saturday night because there were no classes on Saturday night. Friday night, we ran into that damn night classes. So we did it Saturday night so the weekend students could participate. That was the other reason. And then only in the summer. I mean, we did the competition every semester, but in the summer, when the competition was over, everybody was invited back to my house. And we'd have food, and I'd buy a keg of beer, and we'd have a party out on my patio, and we'd go till 2 a.m. It would get pretty loud. It was the one time I ever had a party outside. My neighbors would go, "What was that? We figured it was your kids." I said, "No." Well, my kids that I teach. And, and in the winter, and then when the moot court board had tabulated all the scores and had the names of all the winners and stuff, then they would come later and read all those names. And that's when it would get loud. And then in the fall and winter terms, we'd usually get together at a bar. And often we'd go to Kelly's, and I would give them Lenny or Lynn, who ran Kelly's, I'd give them my credit card and say, everybody gets a couple rounds on me. I'd end up spending $300 or $400, but it was worth it. I got paid well, not great, but well enough, better than my public defender pay, let's put it that way. And I never made much money as a lawyer, but I used to tell my students, if you're a criminal lawyer, you don't make much money unless you're, real experienced in representing hotshot white collar criminals. But generally, no, but you have great stories. If you're a corporate lawyer, you make money, but your stories suck. So that was encouraged. The party, everybody thought, so nobody ever gave me any shit about it. and I was and still am, the happily married guy. And so, like Terry Kavanaugh used to say, hey, we like the pretty girls. We got a lot of them around us at Cooley, but we play by the rules. And I said, you betcha we play by the rules. And that was okay. That was great.
One last thing I would like your insight on. It's gone now, I think, thankfully. But wonder what someone on the inside, if you know anything about this or have any thoughts of it, because I think it was one of the biggest complaints that Cooley students had. And that was, do you remember those rankings that Cooley made where they called themselves like the number 3 law school in the nation based off of,
our biggest library and the most students.
Yeah, and proximity to Brannigan Brothers, right? And I just, as a student, like, I mean, I'm fine. I was cool with it, but I think it was insensitive because I didn't really see what purpose it was serving. And 2, you got to understand, we had a lot of sensitive people that were sensitive about maybe Cooley being their only choice. And then just giving above the law and these blogs like low hanging fruit to just tee off on people that might be already sensitive about where they're at.
I agree with you. And the faculty, almost to a person, was embarrassed by that. We were going, what the hell is it? Was Tom Brennan. It wasn't LeDuc, even though I blame LeDuc for a lot of Cooley's downfall. It was Judge Brennan who founded Cooley. It was his baby. And he was still president, right? And I'll never forget, LeDuc said, when LeDuc was dean and Brennan was president, and Brennan is one of these idea guys. He's always coming up with ideas. Some of them are amazing. Cooley was just his idea, and he made it happen. Some of his ideas are so stupid. And so, actually, Nussbaumer told me this. He said, one of the jobs of the dean is to tell the president when he's full of shit. Well, then Brennan finally retired, and LeDuc was named president and dean. So I said, who's going to tell him when he's full of shit? Well, unfortunately, nobody. But that was Brennan's idea. And you'll notice that eventually just sort of disappeared. It got pushed away. It was dumb. It was absolutely dumb. Now, that being said, I find the U.S. News and World Report rankings dumb. And I think many law schools, that's big news now. Many of the big law schools are saying, are dumb. They're going off reputation. That's one of the biggest factors. Reputation. That means nothing.
Well, I think it's one of the dirty secrets of law school too, is the whole transfer concept, right? Because if you think about it, if you're a high-ranking law school, even though you may get a good student, you can't afford to sacrifice the metrics on who you let in. The GPA you let in, the LSAT score you let in, right? But if you let in a 2L who did well at a Cooley, they're likely to stay in school. They're likely to pass the bar. So you're able to help those metrics in their rankings. And that's why I know some students that got into some really, really good schools. And, if you think about where they got into and how hard it was, 3.0 or above would get you into a reputable school.
No, well, that's the 2 dirty little secrets that I hesitated to share with my students, but I eventually did. Number 1, the first year at Cooley is so hard that if you transfer to another school, you do well enough to transfer to another school. Most of my students who did, because if I wrote you a letter of recommendation to transfer, that was based on a promise that you would at least send me an email, let me know how, after your first semester or your first year, let me know how it's going. Well, most of them didn't. But the ones who did all told me the same thing. It's so much easier here. These kids don't study anywhere near like we did at Cooley, and they said they didn't in their first year either. Why? Well, hey, look, I'm at this good law school now, and they assume that we know it all. And so that's one dirty little secret. Second dirty little secret is that it purges your LSAT score for U.S. News and World Report. When you transfer, that's why they're willing to take you in your second year, but not your first year. If you transfer in your second year, your LSAT score, which if you're from Cooley is likely lower than the rest of their students, doesn't count. for LSAT rankings. That's what MSU took advantage of when they started that second year class up here. But what MSU did that was below, that was really dirty, although they claimed they didn't intend to do this, they promised Cooley students that if you transfer here for your second year, we will wipe out your first year GPA for your class standing. Well, then when those classes came around to graduating, the students who had spent 3 years at Michigan State said, wait a minute. Our GPAs are being hurt by our first year grades too, because everybody's first year grades at every law school are typically lower than all your other ones. It takes you a year to learn how to be a good law student, for God's sakes. And now these Cooley students are going to graduate in all the top 20 spots in the class because their first year grades got erased. And DCL MSU had to say, you're right. So they stuck the Cooley students with their first year grades again. And so their class rankings are up in the top 10, dropped down into the lower part. So they basically pimped them, but I think it would have been a worse crime if they had screwed their own students, the students who had spent 3 years there. It would have been worse. They should never have made that promise. Anyway, but yeah, and it's true. If you can get into it, and I told my students, I don't write letters of recommendation if you just want to transfer down to Michigan State, or if you want to transfer to, like you New York people that want to go to Toro Law School. It's a terrible law school. But if you get a chance to go to Home State University Law School, where the tuition is going to be cheaper, or a better law school than Cooley, which is a lot of them, a higher ranked law school, I'll write you a letter if you can get in. Good for you. And a lot of them did. You know,
Yeah.
one of them even thanked me. I got in the mail one time. She had transferred to Chicago. I think she had a wealthy family. I get in the mail a gift certificate for, some fancy department store I'd never been to before. Not Lord and Taylor, but another one like that. You'd know it if I said the name. But like it's a place where a normal button-down dress shirt is, even 10 years ago, was $150.
Okay.
And she sent me $100 gift certificate for this store. I said, ooh, that's going to get me a lot of clothes. No, it got me a pair of pants. I don't wear expensive clothes. I never did. Now that I'm retired, I get up in the morning. It's like, what blue jeans am I going to put on today? I think this year I wore a pair of corduroys once, Christmas Eve, because my 95-year-old mother was going to be there. So I wore corduroys and a sweater. Otherwise, it's T-shirts, sweatshirts. You know, it's the winter I wear long sleeve T-shirts. In the summer, I wear short sleeve T-shirts. I love it.
Well, I got good news for you. Now that sweatpants are back in and they're making them like expensive and like tailored, or so you can wear those out in public and not look like a weirdo.
Yeah, I've always hated sweatpants. I hate sweatpants. I can't sit in a chair without my phone falling out. And I don't like. I've always looked for sweatpants that don't have that elastic around the ankle. I really hate that. I've always hated that. As a kid, I hated that. I don't know why I hate that. So if I can get sweatpants, I see women all the time in sweatpants with straight legs. I can't find those for men. If I could, I'd buy some. But I'm so comfortable in jeans and shorts. I'm on my way to Arizona next week and for a week to visit my wife's family. And the highs, he said, oh man, the highs are only going to be in the 70s. I said, our highs have been in the 10s. I'm thrilled.
Well, Professor, it was great catching up with you. And
an hour, 2 hours and 15 minutes. Not bad. Good luck editing this.
We got our editing cut, but you brought back definitely a lot of good memories, and I'm sure a lot of people are going to enjoy hearing your stories. I loved my time there, and I loved my students there.
To all my listeners, stay solid and click the subscribe button. And Piano Man, take us out.
Need a lawyer? Are you having financial, criminal, or family challenges? Call or text the Mark Kochie Law Firm, 215-439-7899.